Hi, and thanks for joining us for today's webinar on strategies for using vocational evidence. Before we get to introductions, I'd like to make a few housekeeping announcements. This webinar is pending MCLE credit. In order to qualify for the credit, you will need to stay logged in for the entire session. Hopefully, we'll have enough time to answer many of your questions. If you do have questions, please click on the Q&A bubble on the bottom of your screen and type them there. My name is John Blake, and I'm the Director of Sales here at Gemini Legal. We're always striving to bring valuable content to the applicant workers' compensation attorneys throughout the state. You will be able to find a recording of this and prior webinars on our Gemini Legal YouTube channel. That includes webinars on IMR and UR denials, intake, vouchers, and more. You'll also find attorney interviews and other helpful information there. I'm thrilled to be joined on my panel today by two of the most strategic thinkers I've met around how to use vocational evidence differently. I'll let each of them introduce themselves, starting with Mike.
Hi, and thanks for logging in, guys. My name is Michael Burgess. I'm the managing attorney of MBNA. I'm a certified legal specialist, and I'm a trial attorney and a statistical nerd who's about to geek out on some good proprietary information here.
Great. And Brant?
Hi, my name is Brant Bruner. I'm the managing attorney at Windsor Troy. I'm also a certified legal specialist, and like Mike, have significant experience litigating these high dollar value cases. So hopefully we'll be able to shed some light on our strategies and provide you guys some good insight today.
Great. And thank you both for being on the panel today. Really appreciate it. With that, why don't we get right into this? I'm going to turn over control to Mike and let him share his screen. Guys, it's all you.
All right, appreciate it. I'm going to piggyback. I did a presentation at the TBI seminar in San Diego last year, and I'm going to sort of piggyback on my PowerPoint on that. Let me jump into that. All right, can you guys see it?
Yes.
Okay, let me run through these slides pretty quickly. Quick little disclaimer, obviously these are my opinions and you know, not necessarily binding law, just my opinions. We're gonna go in through, my firm basically, not just workers' comp, but my firm does a lot of civil litigation. And the reason why I just want to go over this is a lot of what I'm going to cover is actually very much applicable in the civil context as well on catastrophic injuries. We're going to be focusing on the vocational side of things here, but just a reminder on workers' compensation. I sort of do a shotgun approach. The first thing you want to do is look at Labor Code 4662, as that may be a separate path to 100%, although there's some recent adverse case law regarding apportionment in that regard. There's Kite and Joel de la Cerda. These are the cases discussing synergistic effect of multiple body parts or multiple subspecialties. A lot of good case law going on that, and that can be upheld on 100%. On SIBTF cases, there's also the recent Todd case that's not on here. So there's multiple paths to 100%. I do a shotgun approach, but today is going to be focusing on the vocational evidence side of things in the Fitzpatrick case. Remember Labor Code 4662. I'll run through that pretty quickly. Kite and Joel de la Cerda. And then, of course, Fitzpatrick. And actually, before I go out of Fitzpatrick, prior to Fitzpatrick coming down, I think it's a third district here, which is technically not binding our district, but most of the courts are following it. There was 4662A and 4662B. And I routinely went to trial when I would have agreed medical examiners or panel qualified medical examiners, finding that my clients were medically unable to compete in the open labor market. In fact, I had 3 cases that I submitted for decision right when the Fitzpatrick case came out. One of them, Judge Glass, gave me the 100% without the vocational evidence. The other 2 rescinded, set for conference to further develop the record. But Brad, you could chime in here. The way I'm seeing this, I don't know of any judges that are going to issue 100% F&A on 4662B in accordance with the fact. I think most of them are taking Fitzpatrick to be binding law. What are your thoughts on that?
Yeah, so I completely agree. I actually had a conversation with a judge who said that right around the time Fitzpatrick came out, that they were basically you know, mandated to have a vocational expert if they wanted to make 100% finding. And so, yeah, the Fitzpatrick decision is a little screwy. You know, there's a big disclaimer. I put together basically some materials that John kindly distributed to those who signed up for this. So you guys can follow along with the materials. But basically, Fitzpatrick case is listed first. It talks about how Fitzpatrick basically found that there's only one way to find 100% disability for a pre-1113 case, and that's an important distinction. And really, it should say that right on the title where it says permanent disability rebuttal post Fitzpatrick, or for pre-1113 cases. And so frankly, I think the decision is wrong, but the result is fine because in the end, even though the case says, you know, 4662 in accordance with the fact you can't go down that road, what the court says is rebutting it using, you know, the Ogilvie method under 4660, or rebutting the DFEC it is viable, and it's basically the same difference. You know, the method is the same. They're both challenged via vocational evidence, and so even though the manner in which the court gets to their holding, the end result is a good thing for us, but in application, it is kind of screwed up, and so. Defendants are making a lot of arguments that basically combine Fitzpatrick with Borman, the Acme Steel case, and we'll get into that more a little bit later. But long story short, same shit, different toilet, as they would say, pardon my French. But that's basically it on Fitzpatrick.
Yeah, and Brand, I agree. So basically, it's kind of a windfall if you're a vocational expert, because it's basically very much encouraging the parties to develop the vocational side of things in order to effectively rebut the rating string, and essentially to show that somebody is not amenable to vocational rehabilitation or has diminished future earnings capacity. So guys, you know, the vocational side is much more important now. And you start off on a case where you are looking at AMA guide impairment, and you may 100%. So there's some cases that are 100% right out of the gate, and there are other ones that sort of get wings later. Remember that most people don't work up work restrictions on some of these cases because they think, hey, AMA guide impairment, work restrictions don't matter. Believe me, on 100% cases, they do. So you want to work up not just all work restrictions, but all functional limitations. You know, from the physical side of things, if you get an FCE or a functional capacity evaluation, and it's important to get the medical evidence to incorporate that FCE and indicate that all limitations that are shown in the FCE are a direct result of the industrial injuries. Because if it's taking into consideration non-industrial factors, you're going to be in trouble on apportionment. Again, work restrictions, work them up. You're going to have some cheesy dad joke slides in here to break up the monotony here. But again, you know, back in the day, prior to Senate Bill 899 in 2005, old law, you dealt with work restrictions. Then Senate Bill 899 comes in. Now it's AMA guides. People are forgetting about work restrictions, but this is very, very important. And you absolutely, on a case that I believe is 100% that I'm going to develop the vocational side of things, I depose every subspecialty if necessary and work up all work restrictions. All right. How I like to do these cases is you think of the catastrophic failed back case, right? And these catastrophic orthopedic injuries, I basically want to try to knock out the physical component and get work restrictions, hopefully limiting them to sedentary activity or less. Next, I try to knock out the mental functioning of this. And this is probably much more important in my personal opinion. Okay. So let's say you get a catastrophic case, orthopedically, they're messed up. They're limited to sedentary work. So basically they're out of that working job and into a more mental job, right? So I think it's really important here. I work up the neurological aspect, memory loss, short-term, long-term. That is really, really important, because if somebody has no short-term memory or has short-term memory problems, how is this person going to be, able to effectively relearn a new job, right? If there are long-term memory effects, how are they going to be able to maintain that knowledge and apply it towards that new job? Work up the psych stuff, anxiety, depression, pain. Brad's going to get into a case a little bit later that deals with sheltered work life. But if you can create a work restrictions from a psychiatric or psychological standpoint, that they need to be precluded from working around others because of anxiety and depression, you just probably won that case there, which we'll jump into a second. Pain, medication, sleep. This is really important. I routinely depose defense vocational experts. The last one I deposed, Keith Wilkinson, last week and a couple months before, literally testified he doesn't take any of this into consideration. Well, that stuff is highly relevant. So you want to work up this stuff so that the vocational expert can take that into consideration. And if you can depose them and they don't take that into consideration, now the report doesn't constitute substantial medical evidence. That report cannot be relied on. But one of the caveats here that, and Brand, we'll jump in and talk about this case, is medication usage. So I deposed this adverse defense vocational expert last week, who basically says, I don't take anything into consideration unless one of the doctors is saying it. So guys, it's important when you work up the discovery on your file, go over every medication, show that that medication is being prescribed because of the industrial injury. Then go over the common effects of this medication, then go over to the individual effects of how this medication is affecting the applicant, and get the medical evidence to put their stamp of approval and agree that those are industrial limitations. Brad and I were discussing, there's a split in some case law. There's actually, Brad, correct me if I'm wrong, there's a case law that is indicating, at least one case law indicating a vocational expert can take that medication and its effects into consideration. And then another case basically saying, no, they can't because they're not a doctor. Fair statement?
Yeah. So that's exactly right, Mike. That's the exact, split from the courts on this issue. Basically, some are saying that it's just fine to have the vocational expert address medication side effects. But the contrary case is obviously saying, the voc expert isn't a medical doctor. And so if we're going to talk about the medication side effects, it needs to be done by the doctor. And so you want to make sure that you have both your vocational expert and the doctors, plural, most likely, because you want to have each specialist, address the issue if you can, because in reality, the medications are probably prescribed for multiple purposes. And so, again, work restrictions are the meat and potatoes of the vocational report. And it's just like you said, Mike, knocking out, physical limitations and mental limitations. And if someone is taking a medication that prevents them from being an effective employee, prevents them from being able to show up to work, if they can't, operate equipment or, be trusted to deal with the public, if they're on some sort of narcotic or, something like that. So obviously you're going to bring this stuff up and have both the vocational expert and the doctor address it.
Right.
Just so there's no excuses.
Yeah. So for the viewers right now, remember that the effects of industrial medication is essentially like another form of a work restriction, which you want to work up. I'd be very careful if there's overlapping medication. Like, let's say this client was on a medication that was pre-existing, that injury was aggravated, and maybe their pain or their medication increased. Potential issue on apportionment there, I would just say I would stay clear of focusing on any medication that has not solely been prescribed from an industrial standpoint. And then guys, one of the easiest ways to win 100% disability cases in vocational feasibility, good versus bad days. This is sort of like one of my secret weapons here. Obviously, good versus bad days is needed when there's subrosa or surveillance. Typically in these 100% cases, you're going to encounter this. So I'm very careful to frame the testimony in the light where that my client has good and bad days, so that if there's some subrosa of them going to the grocery store or going out to eat or living their life, it doesn't, impeach their credibility. Now, I go over what a typical bad day is, right? Hey client, tell me what a typical bad day is. Basically, you want to create a story or evidence that establishes that on a bad day, they would be unable to work and would effectively call in sick at least that day. Okay? A good example I like to use as headaches or migraines. A lot of people with very debilitating orthopedic injuries or compensable consequences will have very debilitating migraines. So for anybody who's ever had a migraine, light hurts, sound hurts. When you get a bad migraine, really the only thing you could do is take a bunch of medication, lay in bed, shut all the lights off and pray you can go to sleep and wake up and it's not as bad. But that's one of those things that I use to show that when they have frequent migraines, that they're essentially bedridden or homebound or unable to work. And then obviously the greater the frequency, the more likely they're going to be unable to maintain a job going forward. All right, guys. So here's going to be some proprietary stuff. When the first thing I do is when I think my client is 100% disabled in workers' comp, and guys, there's a lot of overlap on civil here, but I'm going to focus this on workers' comp. If I think my client's 100% disabled, I'll send a letter or an email to opposing counsel saying, hey guys, I believe my client is unable to compete in the open labor market based on the totality of their industrial injuries. If you agree, please tender the 100% settlement documents. That will never happen, okay? Unless somebody is paralyzed or something like that, okay? Unless it's a 4662 argument. So anyways, you do that. And then I also say, in the event you disagree, let me know if you want to go to an agreed vocational expert to determine the applicant's vocational feasibility. They won't respond. Then I do that and I go self-procure my designated expert. I'm always careful. I will never say my expert, it's my designated expert. Now, lo and behold, my designated expert is likely going to say my client's 100% disabled. Then what I do is now it's the defense evaluation. And I prepare my client for every defense evaluation. Prep them, make sure they know what they're doing. I bring a tape recorder, or you can even send a court reporter, or you can even go down there in person, and there's some case laws allowing that. But it's very important because if a material term that the applicant has relayed to the defense vocational expert is absent in their report, and you confirm that everything they took into consideration for their findings are in the report, you can get it kicked out as basically not incorporating relevant and germane facts in their analysis. And the crux of my seminar here is going to be focusing on attacking an adverse defense vocational expert. So the very first thing I do is I attack bias. And why is this important? The biggest sword I think an applicant attorney has in their arsenal is going to be actually Rule and Reg 10109. This is important. So essentially what Rule and Reg 10109 does is it codifies the defendant's legal obligation to conduct a quote unquote good faith investigation. And it says they cannot limit their investigation to solely procuring evidence to dispute liability. So the defense is not a vocational expert. And when I say I think my client's 100% disabled, they should conduct a good faith investigation. They failed to do so. I go get my expert. My expert says that the client can't work. I send that to the defense. Again, defense is not a vocational expert. So how else can they conduct a good faith investigation but for getting a neutral vocational expert to neutrally evaluate your applicant and truthfully opine as to whether they are amenable to vocational rehabilitation and whether they're unable to compete in the open labor market based on the industrial factors. So this is 10109, and it basically codifies exactly what I said. That is our sword. That is what we're going to use here. Now, established bias. So the defense vocational expert gets set. I get a report, and it'll inevitably say, you know, this person can work and whatever BS, you know, we know what they're paid to do. So the first thing I do is when I set their deposition is I establish all communications. I strongly believe that all communications from a defense attorney to their designated vocational expert are not privileged. However, I just deposed a vocational expert last week where the defense attorney instructed his designated expert not to answer any questions about their communication because he asserted it was privileged information. I will assert that his assertion of it being privileged just shows that that's not a neutral evaluation and helps show bias. Now, I get every bit of communication. If it's been emailed, I get it. If it's been, you know, verbally done, I get the doctor's independent recollection of what that is. As soon as you can establish bias, it is my personal legal opinion that that report is now, well, it'll be admitted into evidence because they have to read it. But if it's bias, I don't believe it's admissible. And at minimum, it wouldn't be substantial medical evidence and it would be able to be excluded. Furthermore, I strongly believe that water flows to the path of least resistance. And if you're at trial with a trial brief and you're saying how and why the defense vocational expert is biased and not substantial, now in order for the court to find against you, they have to show that your expert is not persuasive and then get past all that bias to then ultimately rely on their expert. So I find that water flows to the path of least resistance. It's a good way to get an easy 100% F&A or increase your probabilities. Next, burden of proof. You'll be surprised, but a lot of these vocational experts are new to the workers' comp game because prior to Fitzpatrick, you know, we would develop a 4662B argument and a judge could issue the award based on that. So a lot of these doctors simply, or these experts rather, simply do not know what the burden of proof is. So I say, defense expert, can you articulate to me what is applicant's burden to show that they're entitled to a 100% award based on vocational evidence? It's shocking. Almost no vocational expert can accurately articulate what it is. If they don't know what the burden is, then their entire report is not on valid foundations, okay? I also usually let the vocational expert do a lot of talking. I find that the more they talk, they usually say some stuff that gives you some rope that they can hang them pretty easily. And remember that, you know, injuries to be liberally construed in workers' comp with 3202, but remember that the burden of proof, more likely than not. All right, guys, now here's going to be the interesting stuff where if you guys are watching it, this is what I think is personally going to be really interesting. And we're going to get into some math here, okay? I am in full candor. I'm a statistics nerd. I always have been. Probabilities. I played poker through undergraduate online to help me make it through law school. I'm a statistics nerd, okay? So we're going to use statistics as our friend here to successfully show by even the defense vocational expert that the applicant is entitled to a 100% unapportioned award. All right. Numbers don't lie. Check the scoreboard. All right, let's do this. More likely than not, to me, mathematically, 50% plus a feather, right? So 50.01 or arguably 50.00001, okay? We just need to show more likely than not, our client is not amenable to vocational rehabilitation, meaning they have zero future earnings capacity based solely on their industrial injuries and the compensable consequences of their industrial injuries. Stay away from the Montana factors, things like lack of education, monolingual, lack of transferable skills. You would just want to focus on solely the industrial factors. Okay. Now, how do we get to show our burden is more likely than not based on statistics and math? Okay. It's compound probabilities, more specifically in nerd terms, multiplication rule for independent events. Sounds complicated. It's not, and I'll give you a very easy example. I use the same example in my trial briefs and at trial. Think of rolling a dice. What is the probability you hit a 6 when you roll the first dice? It's 1/6. What is the probability that you'll hit a 6 twice? Well, now it's 1/6 times 1/6, or 1/36, which is about 3%. Now, if you threw a third 6 into the mix, it's now 1/6 times 1/6 times 1/6, or 1/216, I believe, which is literally effectively 0%. So when you break down compound probabilities and you make sure that each and every one of those probabilities has to hit in order for you to successfully show you're able to work, this is how we can statistically crush a defense attorney and a vocational expert, and they don't even see it coming. Okay. What I do is I break down what it is for somebody to be able to compete in the open labor market. And so the first fundamental thing I do is show that somebody is a qualified injured worker. Guys, if we don't have a qualified injured work to start, you are going down the wrong path if you're going down the vocational side of things. And that is that you have somebody who had a usual and customary job, they got injured, they're now unable to do their usual and customary job. Typically, the employer will not be able to accommodate their work restrictions. So now this person is a qualified injured worker. That means they need to learn a new job because their employer is not making those accommodations. So they're a QIW. Next, I then want to show that they need to be first vocationally retrained, meaning they need to learn a new job. Second, they need to be placed at a job. That means they need to be able to submit a resume, get an interview, and ultimately be persuasive in the interview to get the job. Third, they have to be employable. That is, they have to maintain that job going forward for a significant amount of time. I usually argue a year. But so guys, now I've just broken down the ability to compete in the open labor market to, if you have a QIW, an injured worker who is a qualified injured worker, they have to first be able to be vocationally retrained, 2, be placed, 3, be employable. Compound probabilities, ready? So the first thing you need to do is go over the first element. And I say, hey, defense expert, I lay the foundation. My client is, look at all the work restrictions, look at the medication, look at the sleep problems, look at the psychiatric problems. I paint the picture and I lay the foundation why this person is like 0 chance they're going to be able to relearn a new job. And then I say, expert, having laid that foundation, you agree it's not 100% chance they're going to be successfully vocationally retrained. If they say it's 100% chance and you've laid that foundation to show how futile it is, that in of itself shows that report is biased and just not logically sound. So these people will say, okay, I agree, it's not 100%. I say, okay, well, expert, what do you believe is the probability of this exact applicant being able to be successfully vocationally retrained, meaning learn a new job? Now, they'll say some number, 90% or some nonsense like that. And then you battle them back and forth and you show all this stuff. And I find that most of the defense vocational experts, at least the ones that are trying to save credibility and face, will, come down and they'll say 75%. Okay. Now the ones who say, I can't give a percentage or a probability, you just won. What do you mean? If you can't give a probability, if you don't know the probability that the applicant will be able to be vocationally retrained, isn't that your job? You're the vocational expert. You're the one who's saying more likely than not, this person can work. If they can't give you the probability, they're out. Now, let's say that you get them to 75%, right? Okay, so let's say that we've now got them, you beat them down, and they say, okay, 75%. Ironically, this is based on the last 20 vocational depositions I've done. That seems to be what I can get down most of these people to say. Now, next, placeability. So now I have them at, there's a 75% chance this injured worker can be successfully learn a new job. Okay, doctor, now I want you to assume as a hypothetical that this person was able to be successfully vocationally retrained and learned a new job. Then I go over placeability, okay? And I go over all those other factors that make it highly unlikely somebody will, look at their resume, or if they've accepted that resume and they're brought in for an interview, looking at this person who's in a wheelchair or a cane or is disheveled because there's a history of them not taking showers, or they have speech problems. Basically, you now lay the foundation and how this person is unlikely to be able to get a job. Then again, same thing, whittle them down. If they say 100%, show how certain that is. You get them to the lowest probability. Let's say you get them to 75% again. Okay, move on. Employability. Guys, this is the one that's a home run, okay? Employability is the one that I've won most of my 100% F&As vocationally by attacking employability, okay? And you go over the good and bad days, right? And you attack that, and you attack it, and you say, look, this person's going to call in sick how many times a day, right? And you go over this, and you can dwindle them down pretty low on this one, more so. And let's just say you get them to say 75%. Now, you've now got them to testify. There's a 75% chance that they can learn a new job, a 75% chance they can get a new job, and 75% chance they can maintain that job going forward. They have no idea what just happened, but you literally just won your case. If you can get the defense vocational expert to any numbers below 75%, 75%, 75%, you just won. Because compound probabilities, their own designated expert just testified there's a 42% chance this person can compete in the open labor market. Mic drop. Now, guys, even better is you can break each one of those three things into separate subcomponents if need be, so that you further that compound probability. But if you can break down the respective necessary requirements and then show what the probability of that, use compound statistics, it's math. You definitively win. And every expert I've done this, they haven't even seen what's coming. They don't get it. And I'm glad, John, that there are no defense attorneys on this seminar from what I've been told. And I will strongly suggest that we don't disseminate this information to defense attorneys and let them learn the hard way the first time when deposing a vocational expert. Even more, ready for some more statistics, guys? Anyone using like Enrique Vega or some of these other experts, most of the really good experts will focus on SSDI, okay? And again, we're gonna now use some information and some statistics here. If your client is receiving SSDI, there's no way, in my personal opinion, that this person should ever be able to work, okay? Now, obviously, Social Security disability is a different type of law, different burden. Their expert will try to distinguish it. If you're referencing SSDI information, their expert may say, well, this makes them less motivated to work because they're on SSDI. It is a double-edged sword. However, there's something called SGA, Substantial Gainful Activity. And Social Security has kept data of everybody who is receiving SSDI. This is people that Social Security have found unable to work. They have data that basically, depending on the year, and let's just, say $1,310, because that's the most conservative or adverse number for the injured worker. But essentially, there is data from everyone who's got SSDI for decades as to what is the probability that those people will ever go on to make more than what is referred to as SGA. In this case, about $1,300. Drum roll. It is less than 0.5%. What this means is if somebody's on SSDI, statistically, there is data over decades that show that there is less than 0.5% chance that they will ever go on to make more than $1,310 per month. That's not even full-time employment, okay? So if the client's on SSDI and the defense vocational expert can say they work, they're full of shit, okay? What their best way, excuse my language, I'm just piggyback on Brant here. Basically, I think if I'm a defense attorney, I focus on apportionment. I focus on the fact that, that it's because they're on SSDI that they're not motivated, or other things. But to say that they are employable statistically, with more likely than not, knowing we have data showing there's a 99.5% chance that they'll never make more than 1,300. And remember, you got injuries to be liberally construed with Labor Code 3202. I just don't see with the statistical evidence how you lose. All right. So this slide is just putting into context what I've already said. But remember, guys, numbers don't lie. Okay. This is really, really important. So I use statistical evidence to basically show through math that your client has 100% wage loss. And we're going to be turning this over. Brant and I are going to be discussing some cases. Brant's going to take the lead on some cases. And then looks like we'll have a little bit of time, hopefully, to open up some questions. And I'm going to take my slides off here.
All right, so yeah, Mike just mentioned it. He said that the number one thing to be worried about defense challenging and poking holes in your potential 100% F&A is definitely via apportionment. And so there's been a ton of cases recently on this issue. And as I alluded to previously, there's defendants are making arguments basically under stacking Fitzpatrick and Acme Steel Borman and trying to use that to get around the recent case from Judge Feddersen, the Target case, Estrada. So what the Estrada case says is that vocational apportionment is different from medical apportionment. And obviously, that's a distinction that we want to draw every time because it's valid. It's the age-old argument of causation of injury versus causation of permanent disability, and it applies in the vocational context as well. So when an applicant has an industrial injury that takes them out of the open labor market, we need to have the vocational expert address vocational apportionment and basically show that this applicant had no prior disability that was labor disabling, no prior injuries that were labeled disabling, none of these risk factors or pre-existing conditions were preventing them from being employable or earning money or even affecting them at all in the vocational context. And so that's where defendants are trying to challenge and say that under the Borman case, if there is substantial medical evidence of apportionment, it has to be applied. And you don't get to a vocational apportionment analysis because it's addressed under the medical side. I don't agree with that analysis at all. As many of you know, there's a particular retired judge who's given a number of presentations at CAW and SCA and LAVA and all around and written articles for LexisNexis. And basically his argument that you shouldn't get to vocational evidence if there's substantial medical evidence of apportionment is based on a stretch of a reading of the Borman case. So,
Brant, if you mind if I could jump in 1 sec. So spot on, and I think the real issue here the Target v. Estrada case, or Estrada v. Target, shout out to Feddersen. Great case. I think that's spot on, right? Escobedo, you have to look as causation of impairment, right? And so, I think the case is distinguishing whether there's valid apportionment. It's when the vocational expert did not even consider the non-industrial apportionment. I think it's important that your vocational expert consider the non-industrial apportionment and then indicate how and why that non-industrial AMA guide apportionment is not relevant in the context of why the person is 100% on the vocational side of things. And I'll also say, having potentially learned this almost the hard way myself, be careful if you're going to go to trial and you're arguing for 100% and you're arguing that there's no valid vocational apportionment because none of the pre-existing injuries were labor disabling. If you have a fallback on SIVTF and you make that argument in court and you are unsuccessful, you do not have a fallback on SIVTF. Okay, so having almost learned the hard way once myself, I will say that for the viewers as well.
Okay, yeah, and Mike, you're exactly, you hit the nail on the head with the distinction. Basically, what Borman says is all the case says is that the medical apportionment has to be considered by the vocational evidence. It does not say that it has to be applied in no way, shape, or form, and that's the stretch that makes the analysis that defendants are trying to argue incorrect, in my opinion. There's also been a lot of litigation recently on the issue of the 4662A 1 through 4 cases, the presumptions, and whether apportionment can apply on a presumption case. And for the most part, the courts have said no. There was a recent case, the Fryer case, that came out and said, yeah, basically under 4663 and 4664, it should be taken into account. And so be aware that that's out there. But there's so much, and like I said, the Fryer decision is not binding. It's just a panel decision, and there's so many other cases to the contrary. There's Kaiser Foundation Hospitals, which is Dragomir Tremoro. There's this Sanchez case, City of Santa Clara versus WCAB. There's Hirschberger versus Stockwell Harris is another new one. There's just a ton of cases that argue to the contrary. So all these cases are listed in the case materials provided. And then I just also wanted to point out one more case that hit on Mike, your combined probabilities approach, which I think is absolutely genius, by the way. And so when you're
thank you, Brad. Appreciate that.
There's also been a lot of litigation under, obviously employability and those factors. There's a fairly recent case. It's 6 or 7 years old now, 2015. So yeah, 7 years old now, the Gannon case. And this is another reason why work restrictions are so important to the analysis and just can't be glossed over, and you need to work them up and make sure all your medical experts address it. Is because of the Gannon case. So what the Gannon case says is basically if you have an applicant who has a half-time or part-time permanent work restriction, they have to take a nap in between activities, or they can't work a full-time schedule, or they're going to call out 2 or 3 days a week. They're on Social Security disability and they can only work part-time. You want to be careful with that one, as Mike alluded to before, or any statistical analysis, because then you can go down the road of the impermissible factors, the Montana factors. So you want to be wary of that argument. But back to Gannon, the long and the short of Gannon is a half-time work restriction, part-time work restriction, plus a sheltered workplace restriction or being limited to home work If you have a combination of those two restrictions, you automatically win 100%. And that's what the Gannon case stands for.
And let me jump in, that Gannon case, it's, you know, the holding is working from home or sheltered work is not the ability to compete in the open labor market, right? So it's spot on. And you know what, I was remiss, there's a few things I did also want to touch bases on, and I see some questions that we can attack as well. You know, one of the other things that I didn't go over that I want to focus on is, you know, the good and bad days. One of the things I do when it comes to employability is I also ask the defense vocational expert, I say, how many days can somebody consistently call in sick on average per month before they'll be unemployable? I will tell you that any good vocational expert should say 1 to 2 times a month consistently. The most extreme I saw was one said 4 to 5 times, whatever. If you can get the defense vocational expert to a number of days they would be able to call in sick on average per week, that's a perfect hypothetical. Now you've just teed that up. All you have to do is put your client on stand and their wife or a loved one or their husband and just go over how many days they're bedridden, homebound, or that their bad days are so bad that they would have to call in sick. And as long as the trier of fact determines that they credibly testified to having to call in sick more than X amount of time, I even have notes. You know, when I know I'm going to trial, I say for the next 3 months, every bad day, write it down. Then I have that person testify, well, I've kept track of it. In the last 3 months, I would have called in sick 2 times at minimum. And that hypothetical, you just tee it up to win it. All right, some quick questions. Brian, if there's anything else, I think maybe we can attack some quick questions I see here.
Yeah, sure.
Okay. First question I see says, how does an applicant qualify for vocational? What are the requirements? I'm not quite sure what that is, but remember that the 2005 PDR-RS rating schedule is prima facie evidence. First, you have to work up that. Also, the higher you get, you know, work up the impairment, work up Almaraz Guzman, work up Kite and Huel de la Sierra. The closer you are to 100, that is one of the factors they look at. So work it up there, and then you want to rebut it by showing that this person is not amenable to vocational rehabilitation and essentially has zero future earnings capacity based solely on the industrial factors. Be cognizant of the Montana factors. Avoid those Montana factors. Things like lack of motivation, lack of education, monolingual, lack of transferable skills. Basically, what I do is I say, hey, expert, my expert, exclude all of that. And if they can show that this person is not amenable based solely on the industrial factors, that's what I focus on. And if I were a defense vocational expert, they would focus very heavily on that. But basically you would say, like, for instance, if somebody was Spanish speaking, monolingual, no education, at the end of the day, they still would have to learn a new job. And if they're taking Oxycontin and a bunch of crazy narcotics, and they're not sleeping, they have a pain disorder, you know, regardless of the Montana factors, they wouldn't be able to learn a new job because of the industrial factors. So you got to focus on that. I see some questions about SSDI and how to use that. I think that might have been already addressed. Are the slides available for download? I'm hesitant because that's my proprietary work product. John convinced me to share this with everybody. And if you want to individually email me, mburgess@burgessall.com, and I have your assurances you're not going to disseminate it, I will personally email it to you. Another question is regarding a list of good VR experts. Well, this is a double, I got to be careful here. I don't want to defame any vocational experts, nor do I want to necessarily overburden the ones that I'm using because they won't work for me or won't have the time to work for me. I would just say this, there's about 10 reputable vocational experts in the game that are routinely used. You know, if you're really doing this, you'll get to know all of them. I used to use Enrique Vega. It looks like he's retiring and is now leaving that to a new associate of his. I will also tell you that there are some things that were in Enrique Vega's reporting that is relevant to civil litigation that is actually harmful. And let me just talk about that briefly. in civil litigation, they want to know what the injured worker's work-life expectancy is, so that they can calculate the overall lost wages damages. Not relevant in comp. And if you get your vocational expert says they have 2 years work-life expectancy, that's not a good factor for workers' comp, and that will probably minimize any large CNR offer from the defendant. So I take the work-life expectancy out of my vocational side when I'm doing a comp versus civil. Also, in the civil context, they do some things where they're doing physical testing of like manual dexterity to determine their ability to like work on a like an assembly line, that type of stuff. It's a double-edged sword for a comp, because if your vocational expert is relying on testing that he did, discussing limitations for other body parts that are not proven to be industrial, well, now that's a non-industrial factor they're taking into consideration to find the person 100%, and it makes it not substantial medical evidence because it's taking factors outside of the industrial one. So I would be very hesitant or very cautious when there's actual physical testing. All right, we got more questions here. And Brad, John, feel free to jump in while I'm reading these.
Sure. Yeah, there's a quick question about post 2013 cases and using Ogilvy to try and get an FNA that's not 100%, but increase the permanent disability. The courts haven't answered that question yet. That is the question that everyone thought they would answer when Fitzpatrick came out, but the court completely sidestepped it. That question has not been answered by the courts yet. I think it will invariably at some point, but no, we don't have anything yet on that exact issue.
Okay, I see lots of questions about somebody indicating that they routinely get some vocational reports when the PD is low. First, I would just be cautious that the case law does discuss that the 2005 PDRS is prima facie evidence of it being correct. So you absolutely have to show what the strict rating would be. I will say that the lower the strict rating is, the less likely the probability of you successfully rebutting it. However, that doesn't mean you can't successfully rebut if you have low PD, because there are some AMA guide impairment that the impairment may be low, where the work restriction can have a very significant limitation on their ability to work. So while I say it's not directly correlated, I would be very hesitant, because if it looks like a case where it's frivolous to argue that they're 100% and you do this routinely, I can see a carrier going after you and trying to assert penalties, because essentially you're just driving up the frictional litigation costs. And I'd be concerned about that. So there's another question is, what's the lowest PD number? There's no magic number. Okay. I will assert to you that the higher it is, the greater your probability, the lower it is, the less likely your probability, but there is no magic number. And I think it is theoretically possible to have a low PD number and still be successful on a very specific type of case. The next question was, how do I get a vocational involved and when should they come in? First, vocational experts should always come in at the end, in my personal opinion, because first you have to develop all the medicals and all the work restrictions and all the things that we've been discussing. That's the foundation for that vocational report. If you get the vocational expert too early, you're just gonna have to do supplemental after every report comes in. So I typically will get my vocational expert when I'm done with everything on my side. Then I will get my expert. Then I will make my client available to the defense designated expert. I will then depose that defense vocational expert, typically destroy them and be able to win on that alone. But then for good measure, I have my vocational evidence review that report, my cross-ex to sort of cross any T's, dot any I's, and typically their rebuttal report, which we all know that's what it is, will point out the issues with my report, and that final review gives a good chance for my vocational expert to clear up those issues if they're valid, and or distinguish why the defense vocational expert is wrong. And one of the typical things I see is that defense vocational experts will only take, like, looking only at the orthopedic work restrictions, this person can work. Looking at only the psychiatric work restrictions, this person can work. But what they failed to do is take all of them in the totality and combine them. So it's really a good thing to give your, and remember, at the end of the day, you know, most attorneys are not vocational experts. So why not give your expert an opportunity to share their knowledge on how you can win this case. Also, how do you get it? You get the vocational expert by essentially, I self-procure all of it. I set the record that I believe my client's 100% disabled. I show that there's an email that I've asked the defense to go to an agreed expert, and they've said no, or they haven't responded. And I lay that down so that when I go self-procure mine, I don't have any concerns back, and it makes it very easy for me to get this back under Labor Code 5811 cost. By the way, there's case law, whether you win or lose, doesn't matter. It's a cost, you should get it back. The only time you're not going to get this back is if it's frivolous, right? If you have a 12% PD case and you're getting a vocational expert and there's no, real good faith reason, that's when it's concerning.
Yeah, by the way, Mike, that's exactly my same exact process, and I agree 100% with all that.
Okay, I see a few more questions regarding sheltered work. Again, I think the focus on sheltered work is it's not competing in the open labor market.
And some people are asking how to develop. Yeah, I mean, most of the time I just depose the doctor. But I have sent interrogatories too. I mean, if you have a situation where you don't want the defense attorney to take a second bite at the issue of AOE, COE, or something like that at the depot, then if it's something like that, then I may send an interrogatory. Or if I know what their answer is going to be and I just want to get it over with, and I don't want to wait 3 months for a cross-ex, and I just want to get a quick supplemental, so then I can turn around and file my DOR to go to trial. Then I may use an interrogatory, but most of the time I'm going and taking a deposition. It's just easier to hit everything and less time consuming.
Yeah, and Brent, I see some questions on that point. It says, how do you build using your PD using Kite and through QMEs or CrossX? The short answer is it depends on each case, right? I personally, like, when it comes to Kite and Joel de la Sierra and working up, or Almaraz Guzman and the PD, I actually do lean towards doing really good interrogatory letters because it gives the doctor a chance to look at it, put some analysis in it. And if you do good work and show that you're not the path of least resistance, often you find good thought out responses. And even if it's an adverse response, now you get to take a deposition and you get 2 bites at the apple. So I do generally like doing that. There's a question about what are the main factors you look for determining whether to use a VR expert. The short answer is it's a smell test. You know it when you see it. When you truly think somebody is 100%, that is when you do it. I caution anybody to work up the vocational side when it doesn't make sense. Like, hey, I'm going to throw some shit on the wall, see what sticks, cause frictional cost to the defendant to increase their CNR. Careful, because right now we're getting this stuff back under cost without any issues. But if you work the system, that's what creates a bad case law. There's another question. Can you reopen a case where there is no increased PD, but client is now unable to return to work based on new work restrictions? The short answer is yes. If it's new work restrictions, okay, absolutely. Remember that you got to be careful, because when you're PTRing for new and further disability, you have to show it's both new and further. And the PD doesn't need to go up to show that there's been a worsening. You just need to show a worsening, and that worsening caused increased work restrictions, and that now, based on those new work restrictions, they are unable to compete in the open labor market. I absolutely think you should be fine there. Another question on getting the VR experts back on 5811. I've never had an issue of getting it back personally.
Yeah, there's a case directly on point, like Mike mentioned, it's not technically a medical legal cost. I forget the particular labor code it comes under off the top of my head. I'd have to look at my petition, but there is case law directly on point.
Yeah, totally agree. And agree, as long as there's I think as long as there's a legitimate good faith reason, look, at the end of the day, you know, I don't know any applicant attorney who's also a vocational expert. So I'm going to make a reasonable assumption here that no applicant attorney is a vocational expert. So unless you're a vocational expert, how do you know whether your client can compete in the open labor market, right? And when there's sufficient facts, and the short answer is, if the client is working and you're working up the vocational side of things, you should be sanctioned. That's the time you should be sanctioned. That's the time I think you're going to be definitely in trouble, because don't make an argument somebody can't work when they're actually working. Okay. But if the client's not working and you have a good faith argument, I think you're absolutely entitled to work it up. I think you're entitled to your cost back, regardless of whether you win or lose. And I would say go big or go home. And, you know, don't, you know, I would say any defense attorney talking shit to you for working it up, take that as a compliment. Okay. I certainly do.
All right, with that, I'm going to go ahead and close this out. I will send email out to all the participants with your permission, Mike and Brant, with your contact information. So if they have any other specific questions or need of somebody to help them, they can reach out.
Perfect. Guys, one last thing, guys, be careful about Benson apportionment as well. Benson apportionment also applies on vocational cases. And, you know, Benson apportionment is like, just like apportionment is defense burden, but your expert should address it. If your expert doesn't address it, it is not substantial. All right, sorry, little tip.
And actually, the one case that fell on defendant's side recently was actually a Benson apportionment issue.
Yeah.
So the presumption case prior.
Also, shout out to Jerry DeLeva versus Northrop Grumman, which is a noteworthy panel decision of mine.
Oh, yeah.
That says if one of the doctors that the court is relying finds it inextricably intertwined, the entire thing is inextricably intertwined. That's a great case. And
Great
then I have to show one quick thing. How awesome is that picture?
Yeah.
And that's it.
That's awesome. All right, good deal. Thank you again, guys, for being on the panel. You guys were fantastic. I'm sure everybody that was on here got a lot out of it. I will send an email out with the contact information, and look forward to seeing you guys again on a future webinar. So thank you.
Thanks, John. Appreciate it.
Thanks,
All right,
John.
take care.
Take care.